Requisites of a will. Each state has its own requirements for wills in its jurisdiction. Now, some states have adopted the Uniform Probate Code, and so those states basically have adopted the same rules for what makes up a will, what's required for a will. And the idea is that if there's states that are all on the same page about what makes a will, then there's less confusion when folks move across state lines. Now, not all states have adopted the Uniform Probate Code. Texas has not adopted the Uniform Probate Code, but some states have. But overall, every state has its own right, own jurisdiction to make wills, requirements for wills. And those requirements are going to vary from state to state, but there's really more similarities than what there are differences. Most of those requirements are going to be very, very much alike. Here are the requirements for a will that you're going to see in most jurisdictions, certainly here in Texas. First of all, you have to be 18 years of age. Or if you're not 18, if you're under the age of 18, you can make a will if you are married, because marriage, a person under 18 who has permission from parents to marry, and they do marry, that gives them emancipated status, and they're treated as an adult for all purposes. And so if you've ever been married, if you're under the age of 18, even if you're divorced, you can make a will. Or if you're in the armed forces, those folks under the age of 18 in the armed forces, if you got that situation, they can make a will. You have to have testamentary capacity to make a will. That means that the testator, the person that's making the will, has an understanding of the extent of their bounty. That means have an idea of the property that they own, that they know what they own, that they have an understanding of the natural objects of their bounty. In other words, who their family is and who they would naturally leave their property to upon their death. Doesn't mean they have to leave it to those people, but if they have an understanding of who their family is, that's the understanding of natural objects of their bounty. And then, of course, as they make a will, to make a will, the testamentary capacity requires that they understand, the testator understands that they are in the act of making a will. They have to understand what it is they're doing as they're making the will. Now, that will has to be in writing, unless it's what we call a nuncupative will, which is an oral will. More about that later. The will must be signed by the testator or testatrix if it's a woman. The will must also be witnessed. In Texas, we require 2 witnesses. Other jurisdictions may require 3. But in Texas, 2 witnesses are required, unless it's wholly in the handwriting of the testator. If it's entirely in the testator's handwriting, then that it's going to require 2 witnesses. And we call that a holographic will if it's entirely in their handwriting. How do we change or revoke a will? Well, first of all formalities for changing a will have to be met. The same formalities as when you make the will in the first place. You've got to have testamentary capacity that we've talked about. It's got to be in writing. You've got to have it signed. And unless it's a holographic change, then it also has to be witnessed properly under the law. Now, frequently we change a will either by making a new instrument, a new will, or by simply making, well, not so simply, making another document called a codicil. And a codicil is basically a supplement to a will. It doesn't revoke the previous will, it only changes certain provisions of the previous will. And the codicil then has the effect of republishing, revalidating that current will by saying all other provisions of the will are in effect, but these are the changes we are making with this codicil. And then when you probate the will, you also have to probate the codicil. Well, how do we revoke a will? Well, there are a number of ways we revoke a will. Canceling it, tearing it up, Obliterating it, that'll get the job done. Because there is a presumption in the law that if you know that there was a will, but you can't produce the will now, there's a presumption that the testator or testatrix intended to destroy and revoke the will. So revoking, canceling will revoke the will. Executing another instrument, like another will, revokes a will. In fact, when we make a new will, it will frequently read something like, I, John Smith, make this my last will and testament, and I hereby revoke all prior wills and codicils made by me. And then we also can revoke a will by what we call operation of law, as when there is a divorce. A divorce will revoke all provisions in the will that refer to the former spouse. Any gifts made under the will to the former spouse are revoked. Any appointments of that former spouse to executor or trustee or something like that would be revoked. And then finally, revoking a will can also be done through what we call inconsistency. It is possible you can have more than one will. You can, whereas the subsequent will doesn't specifically revoke the earlier will. And if you've got that situation, then you've got two wills, number one and number two, and they may say something different. And so which one do you follow? Well, you follow the later will, and wherever they are inconsistent. So we call that revoking by inconsistency. What type of wills do we have? We've been talking about something called a formal will up to this point on the previous boards. We also have something called a holographic will that we've been talking about as well in the previous wills. That means it's wholly in the testator's handwriting. And then, of course, we've also mentioned a nuncupative will earlier, and a nuncupative will is going to be an oral will. It's not allowed in all states, and there's usually a limit on personal property only passing by a nuncupative will, because the statute of frauds requires that any real property transactions have to be in writing. So automatically a nuncupative oral will is going to be limited to personal property, and frequently there's a dollar limit on that. Then we have a couple other types of wills we need to talk about. A joint will. A joint will is a single instrument that's going to serve as the will of two or more problems. Now there's some big problems, big major issues and problems with a joint will. You've got, I, John Smith, make this my last will and testament. I, Mary Smith, make this my last will and testament. Well, depending on what both of them say, then there may be issues interpreting the will in such a way that you don't leave one of them without a particular provision. It's just not a smart way to go. And then, of course, there's the logistics of once you probate one will, then you've got to go locate that will that's already been probated and probate that piece of paper again. And the family may have moved to another jurisdiction. So it's not a good idea. Joint wills, there's some around, but they're not a good idea. Reciprocal wills, here we're simply saying the husband and wife typically have mirror image wills. Husband leaves everything to wife, names her as executor. Wife leaves everything to husband, names him as executor. They're reciprocal in all respects. But they're not what we call necessarily mutual. Well, then what's a mutual will? A mutual will is usually doesn't have to be reciprocal, but it's contractual, and that's what makes it mutual. Wife is saying, I'm making my will out this way because husband, you made your will out a particular way. And the husband is saying back to the wife, well, I'm making my will out this way because you made yours out that way. And frequently they are mirror image rules. The thing is, when the first of them dies, when the first spouse dies, the surviving spouse is locked in and can no longer change the will. And they're generally not viewed very favorably by the courts, and a lot of lawyers won't do them, but they do have their place as an estate planning tool under the proper circumstances. Okay, and then finally, let's talk a little bit about will contest. In a will contest, someone is, for one reason or another, contesting the validity of the will and saying it should not be honored, should not be put into effect. The contestant who files his will contest must have standing. They have to have some argument, some interest in the controversy, in the will. And they have to have grounds. You just can't contest the will because you don't like what it says. You've got to actually have grounds for it. Like the formalities were not met. Like there wasn't testamentary capacity, or it wasn't properly witnessed, not the right number of witnesses. It may be the witnesses did not sign in the presence of the testator, which is required in Texas, for example. There may be fraud or duress involved in the signing of that will. Someone's being forced to make that will. Very, very important for lawyers and paralegals to be on the lookout for is undue influence. And that happens when the testator's free will is displaced by someone else who would want the testator to make the will a certain way. And that's usually imposed upon the testator by someone very close to the testator, a family member, a caregiver, a fiduciary in some way. We need to be on the lookout for that as we interview our clients and we work with our clients to, particularly those clients that we think may be vulnerable. And so we need to watch out for undue influence. So that's an overview of will contests and the grounds, and overall the requisites of wills.